Our webinar today is on understanding labour agreements and the employer sponsorship process. So welcome, we're very pleased to have you here. And I just wanted to refer you to our employer guide to sponsoring foreign workers, and it's in the link there. You will be receiving a copy of these slides. So if we can move on to the next slide, just want to introduce myself. My name is Yin Chiew. I am the practice leader in the corporate immigration team at LegalVision, and my colleague Kaku Caro, who's also a lawyer in the corporate immigration team. We're very pleased to have you today. So before we begin, as I said, you will be emailed a copy of these slides and a recording of the webinar if you're unable to make it for the live webinar today. Feel free to submit your questions in the chat box. We're going to have time for questions and answers at the end of the webinar. And we would really appreciate it if you could complete the survey after you've viewed the webinar. So towards the end of this webinar, if you want to have a complimentary consultation to discuss whether your business is suitable for a labour agreement, all webinar attendees are eligible for that. So all you would need to do is leave your contact details in the survey, and then we'll get back to you to arrange a time. It's all complimentary. So what are we going to talk about today? It's quite a big topic, labour agreements. So we're going to talk about first, well, what is a labour agreement? And then we're going to discuss the different types of labour agreements. There are quite a bit. Which labour agreement is suitable for your business? And the general process in requesting a labour agreement. And we'll have some time for questions and answers at the end of the webinar. So don't forget to submit your questions in the chat box. So what is a labour agreement? Essentially, it is a solution for an Australian business that is unable to access the traditional skilled migration visa pathway. It is essentially a contract between the Australian business and the Minister for the Department of Home Affairs or the Australian government. There are quite a lot of different labour agreements, and we're going to talk about that in the next few slides. But the labour agreement arrangement really allows an Australian business to access the sponsorship of foreign skilled workers where the traditional pathway is not suitable for their needs. You'd still be utilising some existing visa pathways, such as the subclass 482, the 494, and the permanent residency 186. It does allow you to nominate a certain amount of people you'd want to sponsor in each operational year. There may be some concessions that you can negotiate in that labour agreement in relation to qualifications, experience, salary, English, and age, although it very much depends on the type of labour agreement and whether those concessions may have already been pre-approved. But we'll talk about that in a moment. If we can move on to the next slide. So some key considerations of a labour agreement, and as a starting point for businesses that need to consider whether this option is available to them. The first is really understanding that this is not an application, as you would sort of submit an application for any sponsorship of a foreign worker. This is essentially a request to enter into a contract with the Department of Home Affairs. So it is quite a different process, even though you do have to submit an actual application in IMI account. It's more so a formal process, and the actual request goes directly to the Minister's office or the Minister's unit for consideration by that team. If it's approved, it is approved for a period of 5 years, starting from the date that it is co-signed by the Department of Home Affairs or its representative. During that period, that 5-year period, you can request variations to that labour agreement by submitting a deed of variation. And that's very common to do if you need to increase the number of people you want to sponsor, if there are other variations that you're wanting to get approved during the life of that labour agreement. Typically, it's not available for businesses that have been in operation for less than 12 months, unless it's in relation to the startup stream in the Global Talent Employer Sponsored Scheme Labour Agreement. We'll talk more about that in a moment as well. There are certain conditions that apply when the labour agreement is approved, such as the number of applications or foreign workers you can sponsor per year. You must lodge those applications and have them approved within that particular operational year. A request for a labour agreement very much depends on the strength of your business case submission. And we'll talk about how one prepares that in a moment as well, but it very much depends on that. Upon approval of the labour agreement, the business will be subject to sponsorship obligations. So we'll move on to the next slide now. I've put a bit of a flow chart here because as some of you may be aware, with the standard employer sponsorship pathway, which is the subclass 482 or the 494, typically an Australian business has to be approved as a standard business sponsor, and then they can sponsor on a 482 visa and or 494 visa. And these are typically the steps: nomination application, then visa application. And if we move on to the next slide, you will see the comparison between a labour agreement. So the labour agreement essentially sits in parallel. So if you're a business that is already approved as a standard business sponsor or even an accredited business sponsor, you can also have a labour agreement approved to utilise some existing visa programs, such as the subclass 482, the 494, and the 186. So it is a type of sponsorship approval as well. The process is still the same. If you want to sponsor for any of these visa subclasses, you still need to lodge a nomination and then a visa application. If we can move on to the next slide. So we're going to talk now quite specifically about the different types of labour agreements, and we've categorised them into these sections, which is company-specific labour agreement, industry-specific labour agreement, your designated area migration agreements, or otherwise known as DAMAs, your global talent employer sponsored labour agreement, and the project deed of agreement. So what is first a company-specific labour agreement? It essentially it is a labour agreement that is specific and unique to the needs of your business. And it is typically used by businesses where the standard visa pathway is not available, such as the actual occupation, the ANSCO occupation that you're wanting to sponsor foreign workers in is not available on the occupation list in relation to the relevant employer-sponsored visa. So with a subclass 482, with a subclass 494, there's typically an occupation list that you have to work within, or you have to identify the appropriate ANSCO occupation to sponsor your foreign workers in. The company-specific labour agreement allows you to sponsor an ANSCO occupation that is not on that list. So typically, the occupation lists will encompass ANSCO occupations at level 1 and 2 and potentially 3. If the desired ANSCO occupation that your business needs is an ANSCO occupation 3 or 4, then you may be able to utilise or request a company-specific labour agreement. So some examples of occupations that are not typically on the skilled occupation list is age or disabled carers. So this is suitable for age or disabled organisations that need to sponsor these types of occupations. Age or disabled carer occupations are a skilled level 4. Similarly, you could be, say, a business that needs to sponsor truck drivers, for instance. That is also a skill level 4, and that occupation is not available on the occupation list for the relevant employer-sponsored visa. So in this case, you may have to consider a company-specific labour agreement. There are many other occupations too. One of them as well is beauty therapists. So again, it does allow you to do that, but it then also allows you to essentially create your own ANZCO occupation. So maybe the role or the position that you need falls within a number of different ANZCO occupations. In that scenario, it is called a composite ANZCO occupation, and you're essentially utilizing the descriptions of a few different ANZCO occupations to create an occupation specifically tailored to your business. So there are far-reaching benefits for requesting a company-specific labour agreement for a business that needs those types of requirements. If we can move on to the next slide. So now we're talking about the industry-specific labour agreements, and there's quite a few of them as well. There's the on-hire labour agreement, there's the restaurant premium dining labour agreement. I won't read them all out to you, you can see them all there, but this will be specifically tailored to businesses that operate in this industry. Now, typically with an industry labour agreement, the various concessions around the types of occupations you can nominate under this labour agreement, concessions in relation to salary, age, qualifications, they've already been pre-approved. So there's no room to vary them when you request a labour agreement. They're basically set. So I'm going to hand this over now to my colleague Kaku, who will talk to you specifically about the on-hire labour agreement and the restaurant premium dining labour agreement.
Fantastic, thank you, Yin. So as we can see on the screen, we'll be talking about these two examples. On the first one, for the on-hire industry labour agreement, this is specifically for on-hire employment agencies to sponsor overseas workers. You can assign them to work for a third party, but it is important to know that you must remain the direct employer. Now, why is this labor agreement a good option for you? Well, if you operate as an on-hire labor business, you are automatically not qualified for the standard visa pathway program. So if you operate in this type of field, this is ultimately the only route way for you in order to be able to offer the 482 TSS visa programs for migrant workers and subsequently assign them to work for third parties. Now, the brilliant thing about this particular example is that you can access any occupation that sits on the eligible skilled occupation list. There's no need to negotiate occupations that are not eligible or not in ANZCO, so that's quite important to note. Now, because this particular labor agreement only allows you to sponsor workers under the 482 TSS, unfortunately, there are no permanent residency pathways. However, if you operate in this type of field, it's a great example and a great opportunity in case you're working with clients that themselves are businesses that do not qualify to sponsor migrants under the standard visa pathways, for example, accountants. They may not have the necessary revenue or the organization profile of employees, then you yourself as an on-hire labor can offer that service to your clients. And I'm just gonna state that if you sponsor migrant workers under this particular labor agreement, you have to pay them the base salary of $65,000. Obviously, then you have the specific market rates for each occupation. Now, moving on to the second example, we have the restaurant premium dining labor agreement. Now, it's important to note also that this particularly applies to premium dining restaurants. So this means you have to serve a premium dining experience. You have to have a vast wine menu. You have to operate in that kind of niche field. A few examples of how you can identify yourself as a premium dining restaurant is you employ highly experienced front of staff and back of house staff. You make $2 million in yearly revenue. And most importantly, you're not operating as a franchise. So if you yourself, your business is a premium dining restaurant, you can rely on the existing 482, 494, or 186 permanent residency visa programs. A great opportunity on why you should consider this specific industry labor agreement is that you can sponsor a wide range of occupations that operate in this area, such as chefs, cooks, restaurant managers, sommeliers, maitre d's, and waiter staff. I'll just point out that, for example, sommeliers and maitre d's, you cannot sponsor those kind of workers under the traditional and standard visa programs. And for restaurant managers, even though you may be able to sponsor them, there are no permanent residency pathways. So this is quite a brilliant opportunity for your restaurant in order to retain staff and offer more of an attractive package to your migrant workers. Now, if we'll move on to the next slide, we'll talk about the next category of labor agreements. And this is the Designated Area Migration Agreement, otherwise known as DAMA. Now, you might have heard of DAMAs. You might have known about them. There is a bit of demystifying to do in this area, so I'll do my best. Important to note, DAMAs operate under the labor agreement framework, so they are a type of labor agreements. Now, the main difference to the previous type and categories we have discussed is that it operates the two-tier framework. Each DAMA has already been negotiated with a specific designated area representative that is located in a regional area. So the DAR has already negotiated a head of agreement with the Australia federal government. And the second tier, or the second step, once you have been approved by the DAR, is that you have to lodge the actual labor agreement application with the Department of Home Affairs. We'll look at the process in the next slide, but for now, I'll restate that the DAMA is a great opportunity because you can rely on the 482 TSS, the 494, and the 186 permanent residency visa programs. Now, each specific area has already negotiated the concessions, so they have been pre-approved. And most importantly, why should you consider a DAMA for your business? Well, for two reasons. Firstly, you can sponsor occupations that are not in the eligible skilled occupation list, which means traditionally and via the standard pathway, there are no sponsorship options. One occupation we have already mentioned before is the aged or disabled care occupations. With this specific DAMA, it's an easier pathway because the head of agreement has already been negotiated. The process is a little bit more straightforward as opposed to a broad company-specific labor agreement. Now, the second reason is you can sponsor specific occupations that do not exist in the ANZCO list, such as the rope access technician, specific to the Goldfields DAMA in Western Australia. Now, if we can move on to the next slide, we'll showcase all of the 12 different regions that have successfully negotiated a DAMA head of agreement with the Department of Home Affairs and the Australian government. What you're seeing on the screen, these 12 designated area representatives, what this essentially means is your business, you yourself as an employer, you must be actively operating in one of these 12 regions. If your business is not located in one of these 12 areas, you unfortunately do not have access to a DAMA. You may have access to a different type of labor agreement, such as a company specific, but not via the DAMA program. In each one of these 12 regions, it is important to know that each region, each designated area representative has already negotiated the concessions, meaning there is a DAMA occupation list to each region. They're not all the same. They have the unique requirements for visa applicants as well. So it's important to be quite strategic about it. Understand what are the requirements the visa applicants need and what does the process involve. Now, speaking about the process, we'll move on to the next slide just to show you a bit of a chart flow on what does it entail. There's just one extra step. You must gain endorsement from that particular designated area representative. You yourself as the employer, you shouldn't start the step number one unless you have been actively operating in the area for 12 months. Nevertheless, that doesn't mean that if you have been operating for less than 12 months, you can definitely take some steps in your strategy towards attracting talent, making business plans and taking all of these fees and cost in your budget as well. So that constitutes the DAMA process. We'll move on to the next category, which will be presented by my colleague Yin.
Thank you, Kaku. So the next type of labour agreement is the Global Talent Employer-Sponsored Labour Agreement. And there are two streams available under this labour agreement. It's for established businesses. Established businesses are defined as accredited sponsors. So they are businesses that would be able to demonstrate a 4 million turnover at least and have been in operation for a period of time. For those types of businesses, they can nominate up to 20 positions per year, depending on the occupation. The occupation can be an existing ANSCO occupation, but it can be tailored specifically to the needs of that business. There are pathways to permanent residence available as well, and it is meant to be designed to be a more streamlined pathway for established businesses or startups. So the other stream is startups, and those startups typically need to operate in the STEM industry, and they will have an option to nominate up to 5 positions per year. They do need to be endorsed by a GTES startup advisory panel, and there's a few advisory panels available. So this is an exceptional option available to these types of businesses, particularly startup businesses that may not have been in operation for more than 12 months, but are at different stages of the startup phase, and they operate in one of the STEM industries. So the types of occupations or positions that they need are considered very innovative, niche, and quite cutting edge as well. So if we can move on to the next slide, where we will finally talk about the last labour agreement, which is a fairly rare labour agreement, to be quite honest. So we haven't provided a great deal of information about it because it's not actually utilised a great deal. And the project deed of agreement, labour agreement, is typically designed for those types of businesses that have sort of construction projects in place, and they are designed for them to hire foreign workers to complete those projects as well. But again, it's not a very common labour agreement. If we can move on to the next slide as well. So which labour agreement suits your business? It really depends on many different factors, such as what is the core activity of your business? What industry does your business operate in? Where is it located? How long has it been in operation for? What are the specific positions, occupations, skills that you need? What is the financial status of your business? Are you, as the business, financially viable? If you're looking for a specific type of position or occupation, what attempts have you made to source that skill from the local labour market? You do have to explain things like why the labour agreement would be beneficial to the business. why it would actually assist the Australian economy as the whole, and why you would be at a disadvantage if the labour agreement was not approved. But similarly, the labour agreements are designed to allow Australian businesses to at least manage their short-term skilled needs. So the business will have to explain how they would like to, or how they will utilize the labour agreement to decrease their reliance on skilled migration. It's a bit of a juxtaposition, or it's a bit of a contradiction, you could say, in that you need that skill, you can't find that worker in Australia, but you also need to explain to the Department of Home Affairs how you're using it for a temporary period. The success of the labour agreement very much depends on the thoroughness and robustness of your business case submission. So we can move on to the next slide as well.
Yeah,
and I'll hand it over to Kaku.
Thank you, Yin. So we're discussing just the general process, where to start. What we recommend is contacting us for your complimentary consultation. We will discuss a tailored approach, strategic approach. We need to assess what is your business profile, what area do you operate in, what are your needs, what sort of occupations are you wanting to sponsor and you have shortage, and which areas are you operating? Is it a regional area? Does it sit within a DAMA? Is the occupation allowed under the DAMA occupation list? Once we decide to actually proceed with the application, we must prepare a very detailed business case, as Yin has just mentioned, and provide ample evidence. Once all of that is ready, we can actually then go ahead and lodge either the labour agreement with the Australian government and the Department of Home Affairs via IMI account, or we seek the pre-endorsement for DAMA first, if that is the case. So processing times do vary quite a lot. There's no indicative timeframes, and this is entirely at the discretion of the minister, which is why we prepare an ample business case and provide a lot of documentation. So that concludes the webinar for today. You might find that our publication, Employer Guide to Sponsoring Foreign Workers, useful. As mentioned before, you can download it for free in the handout panel. So now moving on to the next slide, I'd just like to mention that we do also have an upcoming event that may be of interest to you. It's on refund, returns, and repairs, your business legal obligations. It will be conducted on Thursday, 23rd of February at 11 a.m. Sydney time, and you can absolutely register at the link shown on the screen. Now, we're going to answer your questions shortly, which we are pleased that we have received quite a few. So while the rest of you continue to submit them, we'll take a minute to tell you about our membership. So LegalVision, we offer a membership that is cost-effective alternative to the expensive hourly rates you may experience with other law firms. It is, for an affordable monthly fee, you received cost certainty and all-inclusive legal services for your business as usual needs. So it includes unlimited document review, drafting, amending, reviewing, business contracts, and commercial leases. It also includes unlimited advice consultations with our team with 100+ specialist lawyers. It includes business structuring, employment, disputes, and many more. And last but not least, it also includes unlimited domestic trademark registration and discounts on your immigration requirements. So to learn more about how we can help you through a membership, please do request a free consultation when the survey appears at the end of this webinar. So now we'll actually go ahead and proceed to answer some of your questions. So if you just bear with us for a moment.
Thanks, Kaku. Yes, so I'm looking at some of the questions now. So let's deal with the first one. Thank you everyone for putting in your questions. Keep them coming. But don't forget, if your questions aren't completely answered in this webinar, you are able to schedule in a complimentary consultation with us where we can have a further chat and really explore that labour agreement option that is uniquely available to you. So the first question is, what occupations can be eligible for an employer-specific labour agreement? I'm thinking you mean a company-specific labour agreement. So it can actually be all types of occupations, but it's very much dependent on how it aligns with your business. So it can be an ANSCO occupation anywhere from skill level 1 to 4. And it can include occupations already existing or not as well. When I say existing, those types of occupations just may be of a different description depending on your specific needs. So it really depends. The next question is, there's a few different questions. So I'll take one at a time, which is, can you negotiate different occupations outside the ones already eligible to be sponsored? Yes, it depends on the type of labour agreement. So one example is the company-specific labour agreement. You can negotiate a different type of occupation. Most of the other labour agreements, like the industry labour agreements and DARMAs, will already have a set occupation list that you'll have to select from. So the company-specific labour agreement is really the only one that will allow you to negotiate a different type of occupation or design a different type of occupation, but that's uniquely aligned to your business. The next question is, how can a business find recruit the employees they need once LA is agreed to? Look, that is more a practical question, and you may need to obtain the services of a recruitment company to assist you with that. And the next question is, can an on-hire firm get a labour agreement? The short answer to that is yes, under the on-hire labour agreement pathway. Sorry. The next question is a little bit more involved. So whoever wrote this, please feel free to also put in your contact details, because we can contact you to arrange a complimentary consultation, and we can talk to you in much more detail around your options. Again, it's all complimentary. So it is, what are the chances for a beauty industry company to get the company-specific labour agreement if the company is small, just 6 employees with a turnover under 1 million. They want to invite a specialist from overseas, but occupation is available only in regional Australia. However, the company is located in Brisbane. Look, again, it depends on your business, obviously operating in the beauty industry, the type of skill that specialist has, and the strength of your business case around it. So it's not impossible, but without understanding a little bit more about the business, the role, and other factors that are necessary in preparing the business case submission and requesting a labour agreement, I wouldn't be able to tell you for certain that there are good prospects of success. But on its face, it looks like that there is an option available. So please arrange a time to speak to us on a complimentary basis as well. Okay, couple more questions, and feel free to put more questions in as well. Can occupations approved under a company-specific labour agreement lead to PR pathway? Yes, they certainly can. Yes. Usually the permanent residency pathway will be negotiated under the labour agreement at a later date. This is where the business will need to submit a deed of variation during the period of the labour agreement operation. But yes, absolutely. What is the division of costs between the employer and the employee? If you're requesting a labour agreement under any of the different types of labour agreement, then the employer is responsible to pay those costs. It's only once the labour agreement is approved, and then you have to lodge the associated visa applications, which is the nomination and visa application, then the employee can cover the costs in relation to the visa application only. This is an employer-sponsored pathway, so the employer is financially responsible to pay those costs. I think that's all the questions. Was there any last minute questions before we wrap up today? Just a reminder, there is a publication, Employer Guide to Sponsoring Foreign Workers, that you can download. Please get in contact with us if you want to speak further about your business's options for a labour agreement. It's a complimentary consult. I think nope, just confirming with my team, there's no further questions. So thank you very much, everyone, for your time. We hope you found that incredibly useful. And as I said, complimentary consult is available to you. Just need to complete the survey that will pop up at the end of this webinar and leave your contact details, and we'll be more than happy to get in contact with you at a convenient time to talk to you more about your options. Thank you so much, everyone. Have a wonderful day.
Thank you very much. Bye-bye.